I'm Richard Gearhart, an intellectual property attorney specializing in patents, trademarks, and copyrights.
And I'm Elizabeth Gearhart, not a lawyer, but I work at Gearhart Law and I have my own startup.
So welcome to Passage to Profit. I'm so excited that you're here tonight. We have a very, very, very special program for you. We have experts from Gearhart Law who are going to be answering your questions about intellectual property. And these people are off the charts brilliant. You are going to just be bursting with IP knowledge by the time you finish listening to this podcast. But before we get into it, I'd like each member of our team to introduce themselves, and starting with David. David, can you say something about yourself?
Yes. Hi, everybody, and welcome. Thank you, Rich and Elizabeth. My name is David Postalski. I am an intellectual property and patent attorney at Gearhart Law. I've been a partner there for a few years, and my passion is education and empowerment. I am a professor at various universities, and I'm overjoyed to be here and to help all of you. Thanks.
Awesome. James?
Yeah, I'm also a partner at Gearhart Law. I've been with the firm for almost a decade now. Great place to work. And
you're still here, so.
Still here, yep. And my background's in biochem and molecular biology.
Wow. Like I said, super smart. Ashley?
Hi, my name is Ashley Sperbeck. I'm an associate here at Gearhart Law. I've been here almost 3 years, and I have about 10 years experience in tech areas ranging from small molecule chemistry to blockchain technologies, and I love helping new inventors.
Wow, so we can hardly wait to get started. So Elizabeth, can you tell our audience that about this special program today?
Well, yes, normally we don't tape in front of a live audience or allow any questions from the audience, but today we're doing it because we just thought it would be a fun thing to try. This is the first time we're trying it. And actually, Kenya did research, and there isn't a podcast that has this kind of format. So we're groundbreaking today with a brand new podcast format. It'll go on the Passage to Profit podcast. So we'll see what happens. And I'm ready to get to questions.
Yeah, let's get started.
So let's start with Janetta. Welcome, Janetta. We'll unmute you. Kenya's trying. Oh, there we go.
Well, hello, everyone. I'm happy to be here and excited. I have a simple question. Do I introduce myself or do I go right to the question? How does it
So why don't you introduce yourself and say the name of your company if you have one, and what kind of company it is and what you're doing. So you get to do a little promo plug for yourself on this.
Okay.
And then
I'm excited about that. Okay. Hello, everyone. My name is Janetta Warren. I'm the founder and CEO of JW Professional Writing Services. We specialize in writing resumes, cover letters, and optimizing LinkedIn profiles. If you are a job seeker and you need to stand out from the competition, contact JW Professional Writing Services at 1-833-597-7767.
okay, so what is your question for the group?
My question is really simple. I just want to know the nuances. My question is, what is the difference between intellectual property and copyrighting?
Do you want to start?
I think our partner, Dave Postalski, would be an excellent commentator on that question.
Thank you for your question, Janetta. So it is a simple answer. Let's start with the premise that there are 4 forms of intellectual property. Intellectual property being the things that come out of your intellect. You have the ability to let the government know that it is your property, that is something that you get to protect. So the 4 forms of intellectual property is patents, trademarks, copyrights. So copyright is a form of intellectual property, to answer your question. And trade secret. Each of them has different requirements, different processes, different costs, different procedures. Each of them give you a specific type of protection, but copyright falls under the umbrella of intellectual property. Hope that answers your question.
Excellent. Oh, she's muted. Excellent, David. So does anybody else in the audience have a question?
See, Sean has a question. Hi, Sean, you're unmuted.
He hasn't unmuted yet. There we go.
Hi, sorry, my video isn't working. Hi, everybody. So I'm a programmer. So a little bit about my background is I do some programming for the NIH, but in my spare time, I like to do my own personal projects. So I had a question, just a broad question for you guys. I like to trade stocks in my spare time. And recently I purchased access to a stock trading algorithm that uses publicly available data to calculate some trading metrics. I was able to reverse engineer the algorithm in the programming language of my choice. And I want to publish my project publicly, but I'm worried that the vendor that I use to get access to the algorithm might have an issue with that. So I guess what advice would you have for me in this situation?
Wow, that is an amazing question. James?
Yeah, that is a good question. I guess for starters, when you say open source or publicly available, I mean, are you aware that there's no, copyrights or other intellectual property rights attached to that?
I believe so. So this guy, he basically wrote an algorithm in a script on a platform, but the data that you can put into the script is publicly available. And so the script is just a bunch of math operations like multiplication, subtraction. And so
I see. And you're going to take it and then I guess want to publish, your own modifications to it, right?
Yeah, and it's a completely different programming language as well. But yeah, I mean, it's literally just math operations in a specific order using data available to anybody.
Okay, got it. Yeah, definitely. That's great. And, we're going to operate again off the assumption that there's no overriding or superseding, property right, attached to anything. But, in terms of what you create, in terms of, what qualifies as a copyright, there has to be a certain threshold for originality, or there has to be some level of artistic input or endeavor to create an original work of authorship to allow you to get a copyright on the same thing, right? And so there's not a bright line test per se, but what you're describing sounds like you're doing what's required to likely meet the threshold for something like that. Of course, to give a full opinion and evaluation, we'd have to look at that, individually more thoroughly. But assuming everything checks out, you could definitely apply for a copyright on the same. Particularly, we'd be probably looking at the source code as it relates to, what you're developing.
So would I get in trouble if I published my project on GitHub publicly?
Again, operating off the assumption that what you're using is free and clear and no overriding intellectual property rights that, are attributable to a third party, then you should be able to do that. That wouldn't be, an issue then at that point.
Thank you for answering that question. I appreciate it.
Of course.
Great question. I believe I saw Victor's hand up. Victor, do you have a question? I'm going to unmute you now.
Hi, everybody. Victor Sperbeck, and I have an okay knowledge of IP, mainly because I've worked with David Stolsky on a design patent, and he's a good educator and gave me, good basic understanding of patent options. One thing that I never really seriously considered before was doing a provisional patent application, and just finished reading Warren Tuttle's new book, Inventor Confidential, and he's really rah-rah about going for provisional patents. So, kind of wanted to get maybe some discussion around this of when is a provisional appropriate for an inventor, when to go for full application, utility patent, and Warren Tuttle, he's biased toward licensing inventions rather than commercializing them yourself. And I don't know how that plays into this decision making either. So that's my question.
Yeah, that's an excellent question. Do you want to say the name of your company?
It's Inventive Goods.
Excellent. So I think we should give that to Ashley. She hasn't had a chance to answer anything yet. So Ashley Sperbeck has been writing patents for 10 years and many provisionals and non-provisionals. So Ashley, can you please address the question?
Yes, of course. That's a great question. I appreciate you raising that. So provisional patent is very helpful if you're in the process of creating your invention. You might add something to it. Once you file the provisional application, it serves as a placeholder. So you have 12 months or 1 year from that point in order to add things to your invention before you file the full non-provisional patent at the USPTO, which is what gets examined by an examiner.
So can we have David pitch into on the licensing piece?
Yeah, I think to add to Ashley's answer to Victor's question, I think one of the other big reasons, or a few big reasons why you file a provisional, is one related to funding. Some people or some companies need the additional year, yet have the protection in order to approach investors and try to get additional funding for the next stage of their patent process. So that's one big reason. The other probably most important reason is protection. You want the ability to speak about it. You want the ability to talk about it, to present about it. And so having that placeholder, as Ashley said, is really, really important. I often say to people that if your invention is complete and you don't necessarily need a year to kind of figure out how it's going to work, then yes, maybe go straight to what's called the non-provisional, as Ashley mentioned. But for the other reasons we just mentioned, sometimes even if your invention is complete, but you want to raise money and you want to talk about it publicly or whatever you want to do, even filing the provisional at that stage is probably a good strategy as well. Yes.
I wanted to go to Richard for a minute and see if he had any success stories from our clients who have maybe tried to go straight to licensing rather than develop the project themselves, as Victor mentioned.
Well, yeah, we have lots of examples of clients that have successfully concluded license agreements. In the area of consumer products, I won't go into any detail about names, but we've certainly had many toys, for example, successfully licensed. We've had pharmaceuticals successfully licensed, and it really works best when you're trying to license a consumer product if you have a prototype, because the person who is taking the license, or the company that's taking the license, is taking a little bit of a risk by taking your product on. And when you're trying to license your product, you're competing with other people who are also trying to license their product. So having a prototype is really important. That way they can, the prospective license taker can see it, understand how it works, and get an impression of what it's like to really have this product. And that makes a big difference in moving the process forward. So I think that if you're going to pursue a license and trying to license a consumer product, you should have a prototype, which is like a first design of the product, so that the people you're trying to license to can completely understand it.
Great. Did
Thank
that
you for
answer your
great
question?
Yeah, that was helpful. Thank you.
Yeah, great.
Awesome. So moving along, we're going to ask if we have someone else who wants to raise their hand and ask a question.
Wendy Scher had sent in a question, so maybe I'll read Wendy's question for her. So her question was, how can I go from a very small beginning in my home to test my concept and patent it? And that is a very big question, actually, with a lot of parts. So why don't we start with James? And we'll go around the panel and get comments from everybody.
Yeah, it is a big question, as you said, Elizabeth, and it almost touches on Victor's question, a little bit, and what David said around, funding and how best to proceed with, a provisional and what you need to do. I guess, the short of it is, we could say definitively what you need to do, to take a business from your garage, all the way to the stratosphere. I'd be a very wealthy man, right? If I had the crystal ball to be able to predict that. The fact of the matter is, every case is going to be a little unique, right? And you have to decide what type of technology you have and how you're going to then capitalize on that technology. Are you going to be seeking investors, right? Do you need strategic partners or relationships? Perhaps if you're referring to testing, maybe with a university or a laboratory, right? Do you need to seek, I believe I said, outside investment? Do you need to pursue, intellectual property rights before you approach a third party? Or are you just going to bootstrap it, yourself right from the ground? The question is oftentimes for individual inventors, is that feasible, right? Is it feasible to work out of your garage and do that sort of thing? And it ultimately, in my opinion, many of times depends on the product and the technology that you're dealing with. Oftentimes, consumer products can be produced, right? We have clients who will produce or have manufactured products in China, for example. They'll set up their own distribution. They'll bring it into the country. They'll get it around, and it's a great success for them. And they're able to scale from there on out. Depending on your capabilities and needs, like I said, maybe a university or research lab is really going to have the equipment that you're going to need, and that may not be one viable for home use, or two, may violate some zoning laws or other issues. So
you don't want any explosions in your garage, right?
Right, exactly. So you need to be careful about that. So I do hope that answers it, from my perspective. Certainly we could, discuss your individual needs maybe closer, to align exactly with what you're looking for. But I think that should hopefully, kind of cover it.
Okay, Ashley, do you want to pitch in on this a little?
Yeah, definitely. So going off of James's point, it's really helpful to see what sort of IP you can get for your idea. So one of the beginning stages there would be either doing a patent search, trademark search, or copyright search, just to really see what's out there and if it is feasible to essentially design around or get IP protection for your invention.
Excellent.
Awesome. I see
Great.
Sean has a comment. Can we pivot back to Sean really quick?
Yeah.
Hi, Sean.
All right. Well, I don't want to take away from, I just wanted to ask another question, if that's okay.
Yeah, go for it.
So I've heard that products can be vulnerable to copyright and patent infringement on an international level, particularly in China. So I'm just wondering how I can protect my products from being exploited by people internationally.
I'm going to throw this one to both David and Richard. So who wants to start?
David, be my guest.
Yeah, Sean, probably the number one question of any inventor or creator or business owner is, how do I protect myself from infringers in China? And the simple answer is, the only way to really do that, the only way to really stop someone in China from exploiting your patent, trademark, or copyright is to have the corresponding Chinese patent, trademark, or copyright in China. That's how it is for every country. We are living in a territorial system. So if you want to protect yourself from infringers in a particular country, you must file your patent, trademark, or copyright in that country in order to get into the court system in that country in order to stop the infringer. You can, if you do not have the corresponding patent, trademark, or copyright in China, in this hypothetical, you can still do business in China. You can still market in China. You can still sell your product in China. However, it will be selling and marketing your product in a country where you're unable to stop infringers. So as you could imagine, the number one country that most of our US-based clients file their intellectual property in addition to the United States, is China. So for whatever that's worth, my take on the whole thing is that you should be filing in countries where you have a potential market, not just where you are afraid of infringers. You should file in countries where you are manufacturing or producing. That should be a place that you file. You should be filing in countries where you're exporting from or importing to, something like that. But yeah, unfortunately, the only way to stop an infringer in a court of law in a particular country is to have the corresponding intellectual property there as well. Richard, what do you think?
Could they file a claim against me? Oh, I'm sorry.
Oh, no, that's a good question. Can they file a claim against him?
So if they don't have their intellectual, like we'll use China as the hypothetical just to follow it through the thread. If you didn't file in China, but you are selling in China, and that other company that's also selling something similar also does not have a registered form of intellectual property, then there's no claim that they can file against you either. So the question will be, what do they have in China that could potentially stop you? Maybe they filed for a trademark and not the patent, but there is no way in the world, the only way in the world to stop someone from doing what you're doing, from making what you're making, from creating what you're creating, is to have the registered form of intellectual property. Otherwise, nobody can do anything to anybody. So it's a really good golden stick for sure. Richard, what do you think?
Well, I was just going to reiterate everything that you said. It was perfect. It was like absolutely perfect advice. I did want to point out before I get into my follow-up that in tune with modern times and Zoom meeting, we just had a cat walk across the
we got cat bombed.
yeah, we got cat bombed on the video. So if you're listening on the radio, tune in to hear David Postowski's fantastic discussion.
And look at us on
also
YouTube.
look us on YouTube, because
that was a gorgeous cat.
That
Victor.
was a great cat bomb. But not to get too far off the subject here, I agree with everything that David said. I would only add that to the extent that you you need to know who you're doing business with, right? And in addition to getting the patents or trademarks, you want to have an ironclad contract, right? That can also be enforced, and by knowing who you do business with, there are certain companies in China that are more reputable. And so if you don't have a lot of experience, you need to find an agent that can help you connect with somebody who's a reliable and reputable manufacturer. And hopefully then that won't be so much of a problem, right? Because the intellectual property system in China is improving. We're seeing trends in trademark damages, for example, improving. And in general, the Chinese government seems to be emphasizing strong intellectual property rights because now their society is starting to create things. And by creating things, now they want to protect them. But in addition to getting the intellectual property, know who you're doing business with, have a good contract, and hopefully they have a presence in the USA, so you could also sue them in US as opposed to suing them in China. So that's what I would add.
Yes, Victor just chimed in on the chat with the "I'm not a cat lawyer." That was funny. But along those lines, we had a question submitted to us over email from Maria Casabona, who is an investor in the Northern New Jersey entrepreneurial system. And he said, filing an international patent like a PCT implies that the patent is granted. It is my understanding that a PCT filing provides additional time to apply to each country of interest. So I think we need to unwrap that a little bit.
So maybe James?
Yeah.
The cat is back.
We're having continuing cat bombs here, by the way.
Well, I'm allergic, so it's a good thing I'm here. No, it is a good question, and Mario's second portion really hit on it. Is that there is no such thing as like an international patent, or simply by filing a PCT application, you don't have any patent rights conferred onto you. What the PCT does do is give you a delayed decision-making time to decide what countries you do need patent protection in. And when you file in those countries within a prescribed time frame, typically within at least 18 months of the filing of the PCT application, you're able to take advantage of that filing date from the initial PCT filing. So what ends up happening is, let's say, for example, you file a PCT application, but then decide you need to file in Canada, Mexico, China, and Japan. In order to get patent rights in those countries, you need to file a targeted application in each one of those countries, which means you have to pay the fees for each country. You may have to get a translation of the application. Every country is going to be a little different and have its own fees and quirks in the process. And, you know, in some, that's what you're going to need to do, you know, from the PCT stage in order to ensure that you get, you know, patent rights conferred onto you after the filing of the PCT application.
Excellent.
Excellent. That's a wonderful piece. Kenya, you were going to say something.
I was just going to say that I did see another question in our audience from Teresa Davis.
Okay, I want to follow up on this one just a little bit more before we get to Teresa. Hi, Teresa. It's so good to see you here. What I wanted David to, or Richard to clarify. I think David does a lot of our international work. So I'm going to ask David. Mario said that, first of all, could you say what the initials PCT stand for? And then Mario had said filing an international patent like a PCT implies the patent is granted. Could you address both of those points, please?
Yeah, so just a 30,000-foot view, the PCT stands for the Patent Cooperation Treaty. And it was a treaty signed in 1970, and it was signed by about 154 countries, where each of those countries would agree to abide by the same legal requirements needed in order to get a patent. And that's often referred to as an international patent application. But to Mario's first point, just because you file an international patent application does not mean that you have a granted patent. To expand on what James says, you must actually file in one of those 154 countries, get examined in one of those countries, and then achieve a grant in those countries.
I
I'm
think
sorry,
he read that on
I'm
Facebook.
not sure I want to be examined in any country except the US.
I think Mario must have read that on Facebook, right?
Yeah,
So it's on the internet, it's true.
Yeah, I mean, for sure, there's a lot of misnomers about like, oh, there's global patents and I just have to file a PCT and I have protection in every single country in the world. I got a global patent.
Well,
No.
that's how they started it. That's what they wanted. And none of the individual countries wanted that. I mean, at least the patent bar didn't want it in each individual country, but that was the goal, was to have a single global examination, and just never panned out. So
yeah, and it makes sense because every patent office in the world, including the United States, is self-funded, right? So every patent office has to charge its own fees. Everybody has a sense of pride. Every country has a sense of pride in, you know, examining the patent for what it's worth. And so
there's different standards too. I mean, they all have their own different rules and they don't want to let go of them. So probably not a global patent in our lifetime, but.
No. So maybe we should move on to Teresa Davis, who's a Gearhart Law client. I love your products. I hope that you can introduce your company and tell us what your product is and then ask your question, Teresa. I think we need to.
Hello, everyone.
Oh, you know what? There's an echo.
I see.
Teresa, are you by any chance on two different?
Hold on, because I have to use, hold on just a moment. Okay, can you hear me now? Is that better?
Yeah, that's perfect. Thanks.
Okay.
You sounded like you were from outer space there for a minute.
Forgive me. I have a camera on my computer, so I have to use my camera on my phone and then see you all on the computer. So forgive me for that. But thank you so much. My name is Teresa Davis. I am the founder and inventor of Cover Me Clean, LLC. What we do is a car seat covers, child car seat covers, as well as covers of any sort. Also tray covers for like airplanes and hospital trays or any type of tray you want to use it for. Now, my question was that the agent portion of it. So thank you all, Gearharts. Lord, thank you. I was granted my patent for China. Yay!
That's awesome.
I'm excited about that. So my question is I heard you say that you need to find an agent or someone who is familiar with that location in order to start, you know, manufacturing or things of that nature. So how do you go about finding that agent?
Well, you just ask us because we happen to know somebody who does that.
I think Teresa knows that same person too. The wonderful Lisa Ascalise, who we all know and love. Yes, but
Yeah.
it is hard to find an agent you can trust, Teresa. I mean, I don't want to jump in and answer because I'm not on the panel, but here I am. But I think
Well,
that's a
what
good
you're
question.
doing. You're jumping in and
No,
you're
but
answering.
if you didn't know somebody who knew an agent that you could know and trust, how would you find an agent you could know and trust?
Well, you would type in trusted agent on Google.
Because Google never lies.
Yeah.
So maybe
No, I think the best way to answer that question is to look around. I mean, we've always relied on Lisa and she's been flawless. But if you want to compare, we have other contacts. For example, I don't think Josh Scharf would mind if we mentioned his name. People that have done manufacturing in China, if they have an agent and they're happy with that agent, then you could probably get a referral from them. So we have a couple of different people that we can recommend, but if you want to, try it on your own, just, if you're part of any kind of group that, has, a mastermind group or something that has people manufacturing stuff from China, you could definitely ask them. And we also have clients that have manufactured stuff in China, and we'd be happy to make inquiries for you that way too.
Okay. Sorry, I didn't mean to interrupt you, but that was actually my segue in for Lisa.
Okay.
let's give a shout out to Lisa Ascalise, the
Yes.
inventress,
Yes.
with inventing A to Z.
Yes.
Yes.
So, but no, it's a very important question. You need somebody who knows what they're doing and that you can trust, because it's so far away. It's a different language. It's a different world. It's in some ways it's still the Wild West out there. So you really want to make sure that you're working with somebody good. We had a client who used the wrong agent, and she has been with a firm for 15 years. She had a game made in China. All of the product came back totally wrong. And she still, after 15 years, has a container load of this product sitting somewhere because it's just unsellable. So if you don't take the time to pick the right people, sometimes they'll send samples and you'll approve the samples, and then what gets made is different from the samples. You really got to have somebody in there who knows what they're doing. So
Absolutely. There was another question in the chat.
Oh, okay.
Thank you, Teresa. That was a really good question.
Yeah.
Kenya, do you want to call on the person from the chat?
Oh, sure. So Victor, did you want to ask your question, or did you want us to read your question? Okay, so I'll read it. So it concerns budgeting for IP protection. And it says for an individual, hold on, let me just scroll back. Sorry. For an individual entrepreneurial project, let's say you have $30,000 allocated to cover development, prototyping, marketing, and legal. And his question is, is there a rule of thumb for the amount that the percentage? I should have probably let you read this, Victor, because it's hard for me to scroll.
Let me see if I can finish.
I'm going to unmute you and ask you, because I can't scroll and it doesn't let me scroll and read at the same time. Sorry. So I'm going to unmute.
Okay.
Don't mind. Go ahead.
No, so first of all, your question about cost is perfectly appropriate, because cost is part of running a business. And especially when you're an entrepreneur, you have to decide, are you going to put money into marketing? Are you going to put money into intellectual property? Are you going to do pay-per-click? Are you going to put money into development? And all of those are variables, and you're trying to balance all of that, out. Our general strategy is, I think that you should defer investing in intellectual property until you know that you're going forward with the project and you're committed to it. And the first step should be doing a search. And so if you have a $30,000 total budget and you're talking about a product, then it's relative to what your other costs are going to be. But I would just roundly suggest like, 15% to get started. I think that's probably a fair piece. Before you get down the road too far, you want to, if you have a product, you want to do a patent search. If you have a trademark, you want to do a trademark search. The total for that is, probably about, I don't know, a couple of $1,000s if you're working with Gearhart Law. And then there are different types of provisional patents that we can file that get you at least a patent number. They may not be comprehensive like a full patent applications, but we do what are called pre-provisionals, which are basically you do the write-up, we look it over and we file it, and we get at least provisional protection for that. I don't normally recommend that. I recommend a full provisional, which depending on your project could be substantially more in the $6,000 to $7,000 range. But it depends on what your product is, what your other costs are, how, is the patent going to be important to get investor funding if you're going that route, in which case you don't want to give them pre-provisional, you want to give them full application, because they're going to have an attorney likely review your patent, and the investor is going to be, relying on the advice of their attorney. And if it's a well-written application, then you're more likely to get the funds that you want. If it's a pre-provisional, the attorney will say, well, I'm getting the yellow flag. But I hope that answered your question. And
yes, we do it to ourselves, because I think there was a lot packed in there. Budget is a huge concern, but there was one piece of it that we did actually get another question on from somebody through our email. Lindsay A sent the question is like, what is a patent search and why would I do it? And I want Ashley to address that, please.
Okay, sure. So a patent search, we typically look at any sort of published application, patent, anything like that, both in the US and abroad. And it really helps the inventor or entrepreneur figure out if they can get patent protection on their invention and what the scope of that protection could be.
Excellent. Thank you, Ashley. So are there any other questions from the audience right now? Okay, so I see a thank you to James from Teresa for helping with her patent. So we did get some questions through email. So one that just keeps coming up and coming up and coming up is about trademarking a logo. And I want to throw this to David. Like, should you trademark your name or should you trademark a logo is kind of the gist of what I'm seeing, or both, or together, or separate. A lot of people have been asking that.
Yeah, it's a really good question. I think the rule of thumb should be always, which is if you want the ability to use your words separate from your logo, i.e. like an artistic design, like if you look at the iHeartRadio, the heart would be the logo, iHeartRadio would be the words. If you want the ability as a company to use those elements separate, the words separate from the logo, then you should likely file 2 separate trademark applications. If you have them separately registered, then you can mix and match them in any sort of configuration. If you wanted to file what's called a composite mark, again, looking at the iHeartRadio, you see the heart with the iHeartRadio underneath the heart. If you file it just like that, then your protection is just like that. You are married, as we say, to your trademark applications. So if you have the budget to file 3 separate applications, one for the word on its own, one for the logo on its own, and one for the composite mark with the logo and the word, then you should do all that, because then you have every permutation that you're using. But that's the ultimate thing I think I want everybody to realize. Use it or lose it. That's how it works in the trademark system. So if you are not wanting to use your words separate from your logo, then if you want that ability to use them separate, then you're gonna have to prove that you're using them separate, and then that will probably give you the broadest protection. So I'm a big fan of logos. Sometimes logos are great to file because they give you the additional distinctive quality that a company might need, especially when their words are not so great. Maybe they're not so distinctive. Yes.
What?
That's good. No, I was just going to say, use it or lose it. I love it, and
I
you
see.
know,
Yeah.
I'm going to
That's good.
keep
I
that
just,
in
had a, I
mind.
just had a quick question about the name part. So if you have a trademark on your name, can you stop other people from using your name across other social media platforms?
Good question, Kenya. So a social media handle is usually not considered is not considered evidence of trademark usage, right? Because trademark usage is all about commerce, the buying and selling of goods and services. So you're not really selling per se on LinkedIn or Facebook. Maybe you are on Instagram, definitely not on Snapchat. And so it's hard. So you may own the trademark registration, and now all of a sudden you discover somebody on Instagram has your corresponding trademark on Instagram. The problem will be, well, they're not really selling anything, so how could I really stop them? However, there is a bright lining around this. Most social media platforms do today recognize that if you have a trademark registration on a social that corresponds to another social media handle of another user, then you might be able to stop them. But theoretically, no, because there's no commerce there's no buying and selling of goods and services under a social media handle. But really good question. But to avoid one more thing, just to avoid all of this, when you apply for your trademark, I would do a kind of cursory search as to who has what, where, when, and how on these social media handles, so that this is not a pain in your side later. Yeah.
Yeah, that's a big one, because right now I'm trying to get my trademark, and it's the USPTO is waiting to see if other people are going to use similar trademarks that filed or something. I don't know. Ashley's handling it for me. So I'm kind of mad at the PTO, but I'm going to see if I can keep using it.
She'll do it. We know she will.
Yes, she'll get it there for me. But we did have another question about licensing from Victoria. So what is required for you to get your intellectual property licensed or purchased? I'd like to give this one to James.
Go for it, James.
Yeah, that's a good question, and a bit of a loaded question. I guess, for starters, you have to have some form of intellectual property, right? You have to have a patent, you have to have a trademark, you have to have a copyright. You have to have something, that's there if you're going to actually, license or sell the intellectual property, right? Outside of that, you're generally just talking about an idea or a concept. Are ideas and concepts, licensable? Yeah, I mean, the circumstances are going to be considerably more limited, right? Because, what do you have that's tangible, that's related to that? What is the other entity buying into, right? Now, that being said, it may be that you have a pre-existing relationship and you've, licensed a couple things to them. You say, hey, I have another idea. What do you think about this one? And they say, great, let's do it, right? There's going to be some limited scenarios where perhaps, you can find yourself where an idea or a concept, would be. But otherwise, you're going to need, that intellectual property, piece, filed. Again, whether that's a patent, whether it's a copyright, whether it's a trademark, you're going to have it filed and either registered or issued in order to then, license or sell it, to a third party. But once you've obtained it, you have to find the right people. That may be putting out queries to third-party companies. It could be hiring an agent to represent your interests. For example, one of our clients who's been successful in the toy industry hired an individual who is a former executive from a large toy company who represented him, who already knew the industry, who knew the individuals, and was able to call up everyone and say, hey, let me get this guy in front of you, right? Maybe that's what you need at the end of the day. So that's, I think the short of it. I think you just popped up with another message here. It says, I have a patent I would like to license. What are some reputable licensing brokers? Again, that's a good question, and that's, something you want to be very careful about. There's a lot of what I would call unscrupulous dealers in that space who will promise you the pie in the sky, and they will do the minimum, right? They're going to tell you, oh, we reached out to 20 companies, right? No one wanted it. What they're not going to tell you is they sent out some dinky little brochure in the mail that everyone just dropped off the second, it arrived at the office, right in the trash. So again, you have to be very careful in terms of who you're dealing with and how you want to be able to vet, those parties. And like I say, your best bet, it's likely going to be more expensive. But again, going back to my agent example, right? You want to find someone who's going to be that reputable source that's not going to be, a company whose, motivations may or may not be just to kind of, take your money and do the minimum, right? And so hopefully that answers, your question in short.
Yeah, I just, that was a great answer, James, and I really appreciate it. Just so everybody knows what's going on here in the production booth at Passage to Profit. My wife of 27 years, Elizabeth, is writing me notes, and I can't read her handwriting.
So I'm asking him if Gearhart Law, because I think this is part what the question was asking too. If Gearhart Law actually has any people that we could refer Victoria to that are patent brokers that are reputable. And
well, I mean, Lisa would be.
Lisa Ascalise
she would be one person for sure.
So you can see her at Inventing A to Z, ATOZ, Inventing A to Z. She calls herself the inventor. She has a ton of patents of her own. She helps people. She's been helping Teresa. She helps with manufacturing, licensing, everything.
But
she's an amazing
depends,
resource.
Yeah, it depends really on what industry, what is your product, and what industry do you want to go to. So Lisa is great.
Right, David.
Lisa is great for consumer products, but if you have a different type of product, you're going to need to find somebody else. David?
Yeah,
David,
I was going to say that I think it really depends on the technology. We definitely know some brokers in like software, consumer products, life science is a little bit tough, but yeah, I think just kind of reach out to us so that we can learn a little bit more about the product or service, and we'd be happy to make some introductions for sure of reputable people.
Right. So, I mean, you can call us later. You can go on our website and fill out the form. It's gearhartlaw.com, and the form will go to the right person, or you can email anybody directly. It's David at Gearhart Law, James at Gearhart Law, Ashley Sperbeck, Ashley.Sperbeck at Gearhart Law, or Gearhart at gearhartlaw.com. So definitely reach out and we'll see if we can help you.
Yeah.
So we do have another question. Are you ready to move on?
Yeah, I'm just so pumped that this is happening. I can't wait for another question.
Okay, so Victor, Mr. Cat.
The cat man.
I have 3 cats at home, and they do the same thing. One of them tried to knock over my ring light.
She tells everybody about our 3 cats all the time.
And one of them is in love with Richard. It's really funny.
I wouldn't go that far.
Yes, I would.
I'm working on cat inventions right now, actually.
Oh, that's a great. Pets are so big.
I'm going to have to stay in contact with you.
Yeah. Anyway.
So Victor's question was, will a trademark on a domain name protect it? And specifically, under what IP circumstances can another party claim that your URL must be transferred to them? That's a really good one.
I think James, David, whoever speaks first wins.
Yeah, I mean, certainly domain names and trademarks are intertwined, and you should always, in my opinion, do a trademark search first. See what else is out there before you purchase a domain. I can't tell you how many times I've dealt with someone, whether it's a potential client or a client, who says, well, I got some packaging made, I bought the domain, and the product's coming in a month, and they can't get the trademark. And then they say, well, what do I do with all this stuff? The answer is, well, hopefully you can sell it to someone else. I don't know, right? So they're definitely intertwined, and there are proceedings by which you can petition a court to get a domain name transferred over to you. One of which is called the UDRP. David deals a lot with that. But certainly that is a proceeding by which, you can have a domain name from, an alleged infringer, if you will, transferred over to you. Now, that's not to say that that's going to be the case in every scenario. There's been some very well-known cases, one regarding, car manufacturers, where people kind of beat them to the punch, and they were setting up their own website and their website was valid. It was for different stuff. It was a website that they were actively using. It wasn't parked or cyber squatting or any of these things that sometimes entities will do, to try to ratchet up the domain price, right? And so it's to say simply because that you have a trademark on a domain doesn't mean you're going to get it. That's why, like I say, you get your foot in the door of the trademark search, then you should really turn around and look to pursue domain names, perhaps even similar domain names, not even the exact same one, and to look at different top level domains, .coms, .orgs, so on and so forth. There's quite a list of top level domains nowadays, and those are things that you should be concerned about. Particularly, you'll see people in the entertainment industry will buy up basically every derivation, every top level domain, because they can't have someone else out there using it, right? Now, that may or may not be practical depending on costs and budget and that sort of thing, but there are key ones that you should look to go after. And certainly if you believe there's an issue, you should reach out to us or someone else that can advise you on whether you'd be successful in capturing that domain from a third party, because there's no sense in throwing good money after bad, right?
So James, that was an amazing answer. And sometimes we go searching for domains and then we leave the website and it seems like somebody else snaps it up. It's kind of funny. There's almost like somebody's watching or there's some software. So I always say, for $10 or $15, I don't know how much domains cost now, just buy it. If you're going to search it, buy it. And then, that way you're sure that you're going to get it, because I think sometimes cyber squatters see that and then they'll try to sell it back to you at an outrageous amount of.
I have a brief follow-on for this. Just picking up, James, and thank you for that answer, but picking up on the scenario here, let's say that I have a company called Cat Toys R Us. All right, man, I trademark that. And then the question is, do I also have to trademark cattoysrus.com, or is it scoped by that? And regardless of the answer to that question, let's say I do have a trademark on cattoysrus.com. Could that trademark prevent Toys R Us from coming after me and saying, no, that really should belong to us? That would be like a potential scenario, fictitious scenario.
I just so badly want to answer that question, but James, you started this, so go for it.
Yeah, certainly. So I guess there was two parts of the question. One related to, can Toys R Us, stop you and that sort of thing. And, to kind of go off of your example a little bit and just talking generalities, because there's been some issues with Toys R Us going out of business and bankruptcies and different things. But assuming that there is a third party who's what you would call a senior user to a similar trademark as yours, a senior user being someone who's used it in commerce longer than you have, they may be able to come after you and stop you from using your trademark. It depends how similar the marks are. It depends how similar the goods and the services are, channels of commerce, types of consumers, customers, and that sort of thing. So, on general principle, that's how that would work, right? And
if I could just jump in here, the trademark search will help us identify those kinds of threats. So that's why the trademark search is important, because you don't want to make a big investment in your brand, in a name, without knowing what third parties have that they could throw at you. So
I made that mistake once in my life and I'll never do it again. I was like, I'm not spending that $800 on the trademark search.
Yes,
I have Google. I mean, yeah. So no.
Well,
go ahead, James. I didn't mean to interrupt you.
No, I was just going to say, just really quick.
There was a good point to punctuate that comment.
Yeah, remind me of this part of your question, Victor.
I'm sorry?
The first part of
your first part of the question is, does one need to trademark the TLD with?
Oh, right. Yes. You can. There's, a number of different issues, around that. You might have heard there was, a court case that involved, booking and booking.com and that sort of thing. There's a debate on whether, doing a domain like that, whether it's trademarkable, whether it could be, too generic and that sort of thing. The short answer is yes, you can obtain a trademark, on a domain name. Is that going to be guaranteed that you're going to get it? Again, it's going to be, case by case. We're going to have to look at a number of factors. But the short of it is that in circumstances, you can obtain a trademark on the same.
Okay, thank you.
Great.
Is there anything else anybody would like to add to that discussion? Not right now? Okay, do we have any other questions from the audience?
I don't see any right at the moment, but there was a question that I saw on our sheet where some folks submitted some questions. What is freedom to operate? I know we covered that a little bit under the global conversation that we had, but I was just curious to see if someone could expand upon that a little bit more.
Ashley, can you talk about freedom to operate?
Yeah, sure. So it's a great question. So freedom to operate essentially means if you have protection to operate or sell, manufacture your product based on IP owned by others.
Excellent. So I think if you want to elaborate on how we do one of those searches at Gearhart Law, maybe we could throw that to David. Like, David, how do we actually get all the pieces and put them together for that?
Yeah, that's a really good question. We do a lot of those. They're usually in the form of what's called an opinion. So where we are basically researching for a company that may or may not have their own form of intellectual property, right? They may have a patent, they may not have a patent, but they have some sort of product or service that they want to have the freedom to operate in a specific country. And so we basically identify who are the potential barriers of entry for that company. And we analyze those companies, we look at their intellectual property, and we basically formulate an opinion as to whether that company that's wanting the freedom to operate, whether they actually do have the freedom to operate in the United States or Europe or China. And we give them an opinion based on how their product and service matches up against the existing intellectual property that has come prior to them. It's a really, really important step for a company. And it usually is the sign that a company is at a stage of growth where they're now like commercializing, they're monetizing, they're licensing. Their investors are probably asking, should we dump more money into this company, knowing that there are 5 or 6 other companies that are already out there that may have a patent before them? And so the opinion kind of puts the minds at ease, it puts the investors' minds at ease, or puts the potential licensees' minds at ease that they do have the freedom to operate. So it's a really important step to the process, and it's a sign of growth for that company. So when you're ready to do something like that, it usually means that you are at a stage of growth that you haven't been at before.
Got it. I had saw, just going to the investing piece a little quickly, I had saw another question under there. I think it said, what is a trade secret? If I was reading that correctly. Did I read that correctly, Elizabeth?
I'm sorry, what was it?
It said, what is a trade secret? You had mentioned the investment piece to it. So I just figured that would be a good segue into answering that.
Yeah, trade secret. I think Richard touched on trade secrets earlier. But it's when you don't get a patent because you don't want your stuff published, right? And I shouldn't be answering these, you should.
Right, you do not have the legal authority to answer that question.
I don't.
Be practicing law without a license.
I am a patent agent though.
Well, there's even, well, yes, well, you know enough about it, and she's exactly right. A trade secret is a secret that gives a competitive advantage, right? And so it's unlike other intellectual property where you don't go to the government and register it. You create a trade secret by keeping it secret. And you at least want to keep it within your organization. And if you have a larger organization, you want to keep it on a need-to-know basis. And you want to maintain the secret by giving the secret heightened scrutiny or I should say, heightened internal protection, like maybe only putting the information in a database that has a high, limited permission levels, et cetera. So there's lots of things that businesses have that are trade secrets. Sometimes it's technology. Sometimes it's something as simple as a customer list. And maintaining those things as trade secrets can be very valuable assets. And Gearhart Law has a special product that's relatively new in the trade secret area. We will help you define your trade secrets and help you put together a program that will help protect those. But the key ingredient is keeping it secret, because if you go to enforce a trade secret, you will have to show that it was a secret. Now, what is the value of a trade secret? Well, if somebody comes up and invents something, creates something that's identical to your trade secret, but they didn't steal it from you, there's nothing you can do in order to assert the secret against them. It's only if an employee or somebody else takes the secret and misappropriates it. They start their own company, or they sell it to somebody else, or they give the secret to a new employer. So trade secret is very limited in the way that it can be enforced. And some companies have both patents and trade secrets. So for example, you can file a patent on your software, but there may be certain very specific elements of the software that you don't want to make public. And in that case, you can use the trade secret to maintain certain details that are essential to the processes, right? But still get a patent on it. So trade secrets are a very interesting area of law, and there's federal legislation that protects against piracy and theft of trade secrets and sending information to other countries. But to make a long story short, I think that's an explanation of what a trade secret is. Did I answer your question?
It kind of reminds me of the Thomas Edison Tesla debacle. So, Edison had the direct current, Tesla had the alternate current. He was kind of his protege, and then he took it and he started a whole nother company. So I wonder if this was enacted then, how that all would have played out back in the day.
Oh, I'm sure people sued each other. People have been suing each other in this country for years.
Yeah.
And so I'm sure that there was something there, because you're not happy when you put all of this time and effort, you come up with a discovery, and then somebody walks out the door and starts a competing company, right? That's just not cool. Yeah. So I don't know the details, but I'm sure there were lawsuits.
To answer Victor's question, yes, it was George Westinghouse, but Tesla partnered with George Westinghouse on the technology. So,
but who got a car named after him though?
Right.
That's what I want.
I guess he won in the end.
Yeah.
Well, so I mean, Edison is all over the place too.
Well,
I still think
true.
Edison is more famous than
we
Tesla.
live in New Jersey, so there you go. There was another area I wanted to cover real quickly. That were some questions that came in through the email, and this is James's area of expertise. And this is all about design patents. So people are wondering, should I get a design patent or a trademark? Like, what's the difference? And what's the design patent versus like a regular patent is just what they're kind of asking, which means like a utility patent is a design patent worth it. So James, you have been doing a lot of design patents for the firm. What do you think? I
have. And, a design patent, and I think you mentioned trademark in there. Those are two very, very different things. If you're, conflating design patents and trademarks, we need to have, not me and you, but just in general, more in-depth information on what intellectual property is really going to be, right for you. Outside of that, focusing on patents themselves, utility patents versus design patents, they do cover different things. They are, mutually exclusive, and they're two separate property rights. But you could have a design patent and a utility patent that cover the same thing, right? A utility patent is going to cover the inventive concept, whether that's a method of use, a composition of matter, a physical structure, how your invention operates, right, or functions. Design patents, in theory, are devoid of function. Now, there's always going to be some functional element there, but in theory, they're devoid of function, and they're focused on the outward ornamental appearance, right?
I'm sorry, I'm just trying to imagine something that's devoid of function, but anyway, go on.
Not a cat.
Right.
So please continue.
But you know, a lot of times you can think of, for example, the pump dispenser bottles, right? You use them for hand sanitizers and lotions and soaps, right? They all operate off the same principle, but then you think about all the different bottle designs, different ways the dispensers look and that sort of thing. That's what a design patent covers, right? You're not inventing the new dispenser bottle or the new dispenser itself. You got a new design for one. It looks fun. It's shaped like a star or your kid's favorite cartoon character, although that may be a copyright infringement, so you might want to back off of that. But that's really what it is that you're setting out to protect. And like I say, you could have, you know, a utility patent on the underlying inventive concept, and then maybe you down the line you say, well, here's my actual production models, and you know, I'm going to have a couple different designs. Each one's a little different, but we're gonna design patent those, and you can absolutely do that. There's a couple, you know, considerations to take into account, because like I say, you know, utility patents are functional and design patents in theory are not. But outside of that, you know, you can pursue, you know, one or the other or both, depending on the circumstances of the invention.
Yeah, great answer.
Great answer.
So,
There are a lot of
and
questions.
the
Okay.
trademark is completely different because that protects a brand rather than an ornamental function. So on the one hand, you have the protection for the way the product looks, and on the other hand, you have a protection for the product's name, right? And those are really two different types of protection.
So there was one more question that's kind of related to that. If I only have, and kind of related to what Victor was saying earlier too, if I only have so much money, should I get a trademark or a patent?
Well, it depends on your, well, first of all, you should hit your friends and family up for money to do both. That's my immediate advice. Get a second mortgage on your house, because it's definitely worth it.
Get a second. No, I don't
Drain
think
your
so.
retirement account.
No,
No, I'm
he's
just
joking.
kidding. If you only
He's
have,
joking.
if
You know this is being recorded, don't you?
I don't care. My reputation is already
Red
in
flag,
ruins.
red flag.
Okay, so what was the question again?
Well, so somebody's starting a new company with a fantastic idea, and they need both a patent for their idea and a trademark for their company, but they can only afford one or the other. Obviously, the trademark's less expensive, but which one should they get?
I go full patent. You know what? Because the patent, there's a lot of deadlines associated with patents, and if you disclose it at the wrong time, you can run afoul of one of these, one of these deadlines. Trademarks you can file almost any time. They're based on use. So as soon as you start using the mark, you have trademark rights. And so depending on your situation, I usually counsel that you get the patent on file first, at least do a search, and then get the patent on file, and wait until your budget allows for the trademark.
Okay, excellent. So that was pretty much the list of questions that I got. Kenny, did you get any others?
I didn't get any others. And did anyone in the audience have a question that they wanted to raise their hand quickly and ask?
No, so I think that we're in good shape. This has been excellent. Thank you, everybody, for your participation. I know that Victor did send something to me where I can go look at his cat invention loop, which is really cool. Blink surveys. I'm going to go do that right after this.
All right.
Anytime you get cat inventions, I'm really curious to see what you think a cat would actually like.
Because you're like a cat. You're curious like a cat.
Cats don't like anything. We got our cat a big cat tree, and he liked the box, and it came in.
Go figure.
It's actually how to keep your cat from interrupting your Zoom sessions. And you can see how well it works.
Okay.
Oh, okay. There you go.
So
you put the cat in a box?
No, I don't think so. But yeah, this has been a great conversation. These were excellent questions, everybody. And we really enjoyed doing this. I think our team had a lot of fun answering your questions.
I mean,
and meeting
really,
you all.
Kenya, aren't they amazing? I
So
mean, they-
amazing. I learned so much from you guys today. Like I thought I had, you know, a little bit more knowledge of IP, but now I'm like, you're schooling me today. So I'm appreciative of that.
I was so blown away, and I learned things myself. So, you know, it's everybody has a different way of presenting and advising, and it's so much fun to hear everybody talk
For
about
sure. And I think all the listeners
opinion.
are going to really enjoy hearing this on the radio and on the iHeart podcast. So
Yeah.
Yeah, Victor, what's your cat's name?
Stoli.
oh,
Stoli?
like the vodka?
Yeah, named by my teenage son. So
Oh.
So Stoli's going to be famous.
yeah, he is a Siberian forest cat, the national cat of Russia.
Oh, well, let's just
Wow.
hope that the Stoli company does not have trademark protection for.
Yeah,
animals,
I got to
because
get
you might
working
be
on
in-
the trademark.
You might be in trouble.
Yeah. Well, it added some fun to the meeting.
I
right?
think so too.
Next time I should do this from home and bring my cats on.
So we should sign off. So before we go, I want to thank all of our Zoom participants. It was just lovely having you with us today, and we hope that you'll listen to the Passage to Profit radio show on WOR's 710. And we broadcast at 11 p.m. at night. But if
Sunday
that's
night.
too, and it's a great treatment for insomnia. But if you
No,
if you-
it's not. People like this show.
I
Don't
know.
say
do.
that.
We get a lot of great
all right.
feedback.
We get a- and- and
I'm self-deprecating.
We get a
you know,
lot of
you know that by
podcast
now.
downloads. The podcast comes out the next day on all the major podcasts. So you guys will live on forever. And our YouTube channel too.
Well, Noah can cut that part out if he wants to.
Well, he should. So we
I
get,
mean, it's only airing on New York City radio. No big deal.
yeah, right. In Manhattan and the surrounding boroughs
and
and
it's
New
available
Jersey,
on the iHeart app too,
worldwide.
worldwide.
And but it's on the podcast too. And we get a lot of podcast downloads. I mean, we've had people listen to our podcast. We used to have, when the office was open, people would come in and tell us they listened to every single one because we had such great guests and everything. So
Yeah, that's true. So anyway, I was wrapping up, wasn't I? And I was going to say thank you to our Zoom audience again, and thank you to our Passage to Profit listeners. This is a special edition of Passage to Profit. And as I mentioned, please catch our radio program at 11 p.m. on WOR
on Sunday evenings.
on Sunday evenings, and also catch it on the iHeart app. And I'd also like to say and do a special shout out to Noah Fleischman, our producer, Alicia Morrissey, our program coordinator, who's here with us. Hi, Alicia. And Chatterboss, our video editor, and the whole iHeart team. So you're listening to Passage to Profit on iHeart Radio, WOR 710, the voice of New York.